our moderator today. Thank you, Beatty.
Thank you. Listen, thank you everybody for coming. I can't see any of you. I'm assuming that you're all there, and this is a new experience, I think, for all of us doing one of these seminars over Zoom. But we're here to talk about civility, and we're here to talk about why do we have a program for civility. From my perspective, as I get older and more experienced, it's less of a problem, but it has been a problem continually throughout all kinds of litigation for most lawyers. And I'm curious if you all are having problems with civility yourselves. ABOTA, American Board of Trial Advocates, which is putting on this program, I'm a member. Wilma is on the board of directors of the Northern California, the San Francisco chapter, has certain guidelines for civility. So I think if you have no objection, Wilma, we could start with that and talk about what ABOTA thinks about civility and why it's important.
So thank you, Andy and Chris, for helping to put on this program as fellow ABOTA members. The civility program is part of the ABOTA Foundation, which is the educational arm of ABOTA. We put on Masters in Trial programs, Civility Matters, as well as other programs for high schools and teachers. Addressing your question with respect to civility, several years ago, I think in 2009, there was a national campaign and committee put together to address civility, integrity, and professionalism. And they put together principles of civility, integrity, and professionalism. And as part of the materials which you will be provided at the end of today's session, these principles are set forth on behalf of ABOTA, but they apply to all professionals of lawyers who are professionals. And they are very helpful for us, reminding us. So I commend you to read the 29 principles which talk about discovery, which talk about principles of seeking when it's appropriate to seek court sanctions, whether or not you have good cause for bringing motions. And we'll address these throughout our session today. But I wanted to draw this to your attention and commend you to read it. It also talks about, on the last page, conduct expected of judges, and we'll talk a little bit about that today, and giving guidelines expected of judges who work with us in court and in handling motions. So we've attached that as something. I've seen and heard of many lawyers who, if they're having problems with opposing counsel, there's horrible emails going back and forth, there's letters. Perhaps in a meet and confer letter, you might want to quote the principles, the ABOTA principles of civility, a section that's particularly appropriate, or you might want to attach this just to remind your opposing counsel that we should all be abiding by these principles.
Yeah, thanks, Wilma. And I would agree, and also attached to your program, one of the materials you're going to see is the State Bar of California guidelines, which are similar and a little redundant, but they're helpful. Quite frankly, until I prepared for this program, I didn't even know about these documents. But they're very helpful. And the thing to keep in mind, and this is sort of an overview that I have from my years of doing this kind of stuff, and I'm curious as to what the other panelists think, that it sort of really takes two. And it's terribly important, and this is going to be my sort of a recurring theme for me throughout all of this, is that it's important that you remember that civility is terribly important, life's too short, and if you don't engage the way your opponent is engaging, more times than not, you can avoid going down the rabbit hole of sanctions, motions to compel, and things of that nature. And I would just be curious of Chris, what's your take on that notion?
Well, I think that's true. It seems to me that when people get caught up in these sort of uncivility issues, especially when we look at the presentation in this program later that takes place in a deposition, you have to remember your client is funding every move that you make. And if you choose to engage in an exchange of letters or emails or fighting in depositions, you're adding, I think, to the bill. If your client is present and watches this, they've got to be wondering what's going on. You're theoretically supposed to be a professional. And in many instances, people behave like 2- and 3-year-olds, either in depositions or in the manner in which they handle their communications. Civility tends to streamline the entire process. Remember, we are professionals who, in theory, are supposed to provide objective opinions that lead to a practical resolution of the problem. If we find ourselves self-identifying with some of the more subjective aspects of our clients, and that begins to motivate the behavior behind our actions, we do run a risk of running up the bills, demeaning ourselves as professionals in their eyes. Frankly, I don't think it adds much to the litigation at all.
Wilma, what's your take on that?
Well, I agree with all of your comments, and I enjoy the perspective of that you have both given. If I can just, this ABA Journal article, again, this is enclosed in your material. I commend you to read it. This actually stems from January of 2013 and talks about keeping it civil because, as Andy said, it takes 2 to tango, but it has been a problem across the country. It's a problem, what we're seeing in the media. It's a lack of mentoring. It's television, it's TV and films about lawyers. And it's something that we need to be concerned about is you can be an aggressive advocate for your client, but going to the point of being rude doesn't, it's a fine line, but we should be cautious and conscious of when we have crossed that line into being rude and inappropriate. So that's just a little bit of background perspective. And policing our peers is another concept that I would introduce. We can, with opposing counsel, but also if you see inappropriate behavior within your law firm, it's something that should be addressed on a one-on-one basis.
Right. You know, and that's right. And to take up on a point that Chris made, you know, you have to get to the end. And if you're driving a taxi, the best way to drive the taxi is to get from here to there as fast as you can. And it's the same thing with a lawsuit. I mean, you don't need time. You don't have time for the extraneous stuff and the side fights. Often you're billing your client the way Chris mentioned. But also it just creates a distraction, and you got to keep your eye on the ball and do your best to stay out of these fights. Wilma, you want to go to the next slide, please? I guess that's sort of why we're here. Is lack of civility a problem? I could tell you personally, from my perspective, it's not that much of a problem anymore. And part of that, I think, is me just getting older and learning from all the mistakes I made in the past. I'm curious if Wilma and Chris have a different take.
As I mentioned earlier, I spent about 39 years doing corporate litigation, and there were times when we would deal with lawyers in situations that just defied credulity when it came to civility. I mean, it was a fist fight from beginning to end. In one case, we had a series of depositions. Plaintiff was deposed for 9 days. Tempers got frayed. Walking out of her house that afternoon, the plaintiff's lawyer said something to the defense lawyer, and we've got a fist fight between these two in the front yard of the house. And that's when I realized there was a civility problem in the case. But you see this over and over again, and it manifests in the way that people behave in depositions, the way they behave in the exchange of emails and letters, and behavior that, frankly, if it was among siblings, would be disciplined immediately by parents. But as Wilma pointed out, I think there are certain expectations that have been created in our society largely, I think, from watching some of the political shows and what goes on that the media displays for us, what happens in movies and TV shows. And there is a belief that a lot of this actually occurs in real life, and there's an attempt to create it in real life, thinking, well, this is how it should be performed. And the result is you get a system that now the courts are really decrying, saying we're no longer a profession. We've sort of degenerated into a business with people engaging in this uncivil behavior with results that frankly are not worthy of what the profession was designed to do. So yeah, I think lack of civility is a major problem. I haven't seen it so much when I transitioned into working with my wife in a smaller law firm doing estate and trust litigation. At least I said that at the outset. After 2 or 3 years of this, I'm appalled at what siblings do to each other in terms of fighting over money. And there is, I think, a recurrent theme that I'm beginning to see where there is a lack of civility, even in what I thought was going to be a relatively laid-back portion of the legal profession.
Wilma?
So I'd like to turn to, I think there is a lack of civility in lawsuits, in handling civil lawsuits, and it's unfortunate, and I wish it wasn't. And I try to do everything that I can, including at the very start of a case, calling up opposing counsel, introducing myself, if possible, meeting in person, maybe offering to have lunch or coffee together, so you get off on the right foot. But I'm just going to advance to the next slide and talk for a moment about, we are seeing more and more decisions by the courts which address the fact that there is a lack of civility or incivility in the cases. And we've got a couple of examples of 2019 cases. This one is LaSalle versus Vogel, 2019, 36 Cal. 5th, 127, where the courts have urged counsel to turn down the heat on their litigation zeitgeist. I don't even know how to say that word.
You said it correctly.
Well, that was luck, not experience. Far too often, the courts are addressing, and more judges and justices are calling out attorneys for behavior that is uncivil. My understanding is the LaSalle opinion was written by Justice Bedsworth, I believe it is, not Judge Bedworth, who has been from Southern California, who has been very helpful in both in his court and also with ABOTA in preaching the word, so to speak, of civility and putting on civility matters programs as well. This opinion also addresses something I'd like to raise, which is in 2015, the state of California amended the new attorney oath to add a sentence at the end of the oath talking about, I will faithfully discharge the duties, and I'm reading the new oath, I will faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability. As an officer to the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. And there are, I can tell you from my experience as a national board rep, there are 22 states who have amended their oath to include civil language, civility language, such as this example. And we're pushing to get all 50 states to amend their oath if possible, because we feel it's very important, not just for experienced attorneys like ourselves, but also very important for new attorneys to learn that, to take the oath, and to get it right from the beginning.
Yeah, you have to understand when you're doing these cases, and personally, I've done cases that are very emotional. They involve people losing loved ones. You're the professional. You're the one who has to steer the ship as best you can, and not feel the emotions that the other people are feeling, and be the pro, be the professional, keep it civil. You're more likely to get what you want if you don't get sidetracked. And incivility is really a distraction. And you're hurting your case, you're hurting your reputation if you go down that road. And at the end of the day, all you really do have is your own reputation. And if you get the reputation as someone who's going to be difficult, it's going to create problems for you and your clients in the future. So this is all to make you a better lawyer as well, to abide by the guidelines and the rules. Wilma, you want to switch the slides now? Okay. This is sort of an add-on to this discussion because of the pandemic. And, you know, litigation can be anxiety producing. We all know that. And I'm sure all of us know that this pandemic has created its own new set of anxiety for all of us. So it's just more of a challenge. I hope that you all have made reference to the emergency rules put in place by the Supreme Court and the governor relating to litigation. They're the rules regarding service. They're the rules regarding depositions, whether they're in person or over Zoom. They've all been put in place to make things run smoother. But at the end of the day, it's all on us. It's all on the lawyers. It's all on the professionals. And I think if you set the tone, things will move forward more smoothly. I had never heard of Zoom before the pandemic started. I'm now taking, I don't know, many as 10 depositions over Zoom. My clients have been deposed. I've deposed defendants. I even did a mediation in Los Angeles over Zoom. So things are changing. I don't know what your all experiences are with the pandemic and the new and what's new with that. Wilma, why don't you start?
Well, the one thing I would add, the emergency orders apply, and we all should be following them as far as remote depositions, service by email. But also, I find that I have probably been more generous about extensions. And, you know, normally if somebody asks for an extension, we should be courteous in giving extensions and discovery anyway. But especially in the time of the pandemic that we're in right now, most offices are at least partially working remotely, if not 100% remote. Our office is remote right now, and will continue to be until the governor changes the current situation. And so that's something to consider. While under normal circumstances, you might want to be filing that motion to compel, seeking sanctions. Think about it twice. We're all in this boat together
Right.
during the pandemic. And so now more than ever is a time to be civil.
Right. And the last thing a judge wants to hear, as the two of you are fighting over something that is pandemic related. I mean, as Wilma just said, and I couldn't agree with her more, we're all in this boat together. And it's a challenge for all of us. It's new for all of us. But it's more of a reason to be civil, quite frankly. It's less of a reason to toe the line. Chris, you want to add to that at all?
Only that I honestly think that civility gets you more than being uncivil. And in the long run, there are penalties that you're going to wind up incurring if you find yourself taking people's defaults, not granting extensions, trying to condition an extension on perhaps not raising certain affirmative defenses or waiving this or waiving that. It gets around the community pretty quickly. And I think the pandemic has exacerbated the litigation situation somewhat. And you're right, we're all in this together. There's going to have to be some give and take on both sides. And if you start injecting uncivility into the equation, the system starts grinding to a halt because of the actions you're undertaking. So I could not encourage people more to take a real look at what you want to fight over, and is it worth engaging in the kind of conduct that we're going to be discussing throughout this presentation.
Thanks, Wilma. You can go ahead and flip the slide.
Sure.
All right. We're going to talk about a few scenarios. This is, what do you do if your client insists that you play hardball with opposing counsel? I have my thoughts, but I'll defer to Wilma first.
Well, the first thing is who's in charge? It is your lawsuit, and yes, you are representing your client, but you have to sit down and explain to the client that there are reasons for cooperating with opposing counsel. And as somebody has just said, it's what's the end game and how do you get there quickly, as opposed to spending a lot of time fighting, spending the client's money fighting. And certainly if you have a client who just won't listen, you can explain to them that the California Attorney Guidelines of Civility and Professionalism, Section 3 says attorney should not allow a client to prevail upon the attorney to engage in uncivil behavior. So again, this is a profession, you're the professional, and it is your reputation, as somebody said a moment ago, that we're dealing with. So I think that you have to be the one to explain it to your client.
Yeah, I completely agree. I've got a really good friend who's in the construction business, and he's in litigation all the time. And he tells me all the time that it drives him crazy seeing the lawyers getting along with each other. And I've got to explain to him, listen, he shall go nameless, but you've got to understand we're all trying to get to the same place. Either the case is going to get settled or the case is going to get tried. And it doesn't do you, your client, or yourself any good to explain to the other side how you're going to beat them up. Just go ahead and do your case, accommodate each other, and if you can't resolve it, you could try it and let someone else decide what it is. But I don't even know what it means to hardball with opposing counsel. Don't give extensions. Don't give continuances on depots when someone's in the hospital. I mean, that's just crazy. You can't, as Wilma said, you have to be the grown-up in the room. Or maybe those are my words, but that's what the answer is. You can't let your client call the shots because he or she doesn't know what shots need to be called. Chris, do you have any thoughts on this?
Well, yeah, and it really stems from the experiences I've had over the last 5 years in the estate business where you have battles over the trusts. In so many instances, I think clients' motivations about playing hardball are really driven by unrealistic expectations about what they think they're going to recover. And one of the things that we've tried to do is sit down with them and really have a heart-to-heart talk about realistically, what is it you want to accomplish with the lawsuit? In some instances, it's really not the amount of money that's involved. It's the fact that on the other side, there may be a sibling or a parent or whatever, and I really want to cause them a lot of heartache and misery. And I want you to do that through the following mechanisms, whatever it may be. And we find ourselves sitting down and saying, look, we can't do that. You don't, and here's a realistic expectation of what your fees are going to be if you pursue that particular course of action. This is what you'll probably achieve by doing it, or not achieve for that matter. With respect to the monetary considerations, if they've really got their head in the clouds about what they think they're going to recover, we found it makes a lot of sense to sit down and really go through with them what in the end they can expect to recover given all the fees that'll come out, and particularly if you engage in this sort of hardball approach to litigation. And I find in many instances now, people tend to take a step back, and once they're confronted with hard numbers, they're more apt to listen to you in terms of how the thing ought to be handled and the manner in which you ought to approach the other side, no matter how much they may despise their sibling or parent or whoever the defendant happens to be.
You can go ahead and hit that button, Wilma.
Okay.
Wilma, you wanted to handle this one?
So this is actually one of my favorite topics because I don't know what it's like to have a partner who encourages you to be uncivil. When I was a new attorney here at McNamara Law Firm, all of my partners, I think pretty much all of my partners were members of ABOTA, and they practiced and they preached civility, professionalism, and they taught all of the attorneys, and I do the same with young attorneys now, that you should be civil, that you should be professional. But for any of, and I can't see you, I don't know exactly who has registered for this, but for anyone who might be a young solo practitioner, or anyone who is in a firm where you have a partner who is telling you to use a style or practice that in civility, it's uncivil. And so I would empower you to break that chain, and to make a change, and to say, you know what, I know there are attorneys out there who, if I treat them with respect, they will treat me with respect. So I empower you to break the chain.
Yeah, and let me just say that I understand what you're saying about the McNamara firm. Not to give you a plug, but I have not litigated cases with any other firm more than I have with the McNamara firm over the past 40 years. And I actually gave this talk to the McNamara firm, not that it was necessary, but you could tell from the top down at McNamara, which is not a small firm by this county standards for sure, that they're well mentored and they understand, listen, they've got some tough lawyers there, Wilma being one of them, and they're formidable opponents, but they're not jerks. And there's a big difference between a formidable opponent who knows the law, who's going to take the case to court if they have to, and someone who's just a pain. So I second and third what Wilma just said. If someone at your firm is acting inappropriately, it's not doing that firm or their clients any good. And it really is your obligation to jump in. Chris, you want to say anything, or should we move on?
Just a couple of quick thoughts. If you're in a firm and you're working for a partner who's uncivil, and that's the style of practice in the office, you're kind of between a rock and a hard place, I think. You can go to the partner and say, I'm not sure I want to work for you anymore because you are uncivil and you're violating a variety of language and the various things that have been imparted in the program so far. But that's going to mark you as an outlier. And if this is the style of practice in your office, it's difficult for you to transition to another partner or another senior associate to work for them. Trying to bring change inside an atmosphere like that may prove so difficult that you're better off looking around to shift firms depending on what your situation is and what the availability of other procedures or other offices are. But it's a very difficult situation if you find yourself in an office that traditionally kind of practices hardball, and this is the style of the guy you're working for.
Okay, Wilma, we can move ahead. Let me offer my 2 cents on this one. What do you do at a deposition if your opponent improperly objects, coaches the witness, or insults you or your client? Number one, and I learned this about 20 years ago in a medical malpractice case that I was doing. If you've got a person on the other side who acts this way, it's mandatory that you videotape the deposition. And it's my sense that most depositions need to be videotaped. Not necessarily for that reason, but it's just a good idea to spend the money. If the case is that important that you've taken it, it's worth videotaping. And in this particular case that I started videoing the depots, the temperature went down about 90 degrees. I mean, it was unbelievable the change when the lawyer on the other side knew that he was on video rather than just on a transcript. On the other hand, if your opponent is improperly objecting or coaching the witness, you might have to take a break, and you have to call that person's attention to the problem immediately. Otherwise, it's going to go on. I have not had an experience ever where my client was insulted, but maybe I'm in the wrong line of work. I'm curious what other people have to say about that. Wilma?
So I want to draw your attention to, during a deposition, never engage in conduct which would not be appropriate in the presence of a judge. And as Andy said, if you're videotaping that deposition, or even just based on the transcript, those are going to be exhibits in a motion in front of a judge. Is that the record that you want to make? And this is quoted from paragraph 20 and goes on in 21 of the principles of civility, integrity, and professionalism put out by ABOTA, very similar to the California Attorney Guidelines, section 9.3, treatment of another counsel. So these principles are out there because we have all seen circumstances where objections, an objection, rather than to the form of the question, objection, that's ridiculous, don't answer it. Objection, you're, or an insulting of opposing counsel. We've heard it, but don't be that person, I think is the message that I would leave you with.
Yes, and this is a little nuanced, but it's worth knowing. Sometimes, and you got to read the room correctly, sometimes if you don't engage the other side, it goes away. I like to say, certainly when my client's being deposed in a plaintiff's case, the goal is to get out of there as fast as you can. And the more you engage, the longer it's going to take. So if appropriate, under the right circumstances, and you're the professional, you would know this, if you don't engage and it doesn't go on too long, it might be best just to let it slide. But on the other hand, if it's persistent and it's insulting and it's affecting the content of the deposition, you really have no choice but to get involved. Chris, you want to speak up on that?
Well, yeah, I've got a question for both of you. Have you ever had a situation where the conduct got so egregious that you basically had to stand up and terminate the deposition and walk out?
Well, sort of once, yes, with an explanation. I had one lawyer on the other side of a case that I had where he was nothing but trouble. And I decided from the outset I needed a discovery referee. And I'm thinking in my mind, 40 years, one discovery referee, that's not too bad. But it doesn't happen very often. But it can, and you have no control of it when it does happen. And worst case scenario, you get a discovery referee. I forget the code section, but it's a recoverable cost. And if you win and you've got to resort to a discovery referee, that could be real expensive. I had, in this case I just finished up, there was a huge issue with a cell phone and downloading a cell phone. And first we thought about getting a discovery referee, but we actually worked it out. And we came up with an order and a stipend order, and it all worked out. But that's not a bad alternative when something like that happens, Chris, to answer your question. Wilma?
But Chris, I can't remember a time in my 20 plus years that I've ever stood up and terminated a deposition for uncivil behavior. I believe in kind of turning the other cheek and proceeding with the deposition wherever possible. That having been said, you want to make a record and try to meet and confer. I have stopped a deposition. I have invited opposing counsel and my personal counsel who was working with me to leave the room, leaving the witness, the clients, and the court reporter in the room, and told the opposing counsel and the personal counsel and I said, we're going to stay in here and I'm not going to open this door until we work this out. That was using my best mommy voice. We are going to work this out. And it was successful and things calmed down for the remainder of the deposition. But I had to be very insistent. So that's how I dealt with it.
Okay.
Thanks, Wilma. We can go ahead. Right. This is interesting. I'll just play it as I think it speaks for itself. And if you have any comments, you want to ask a question about it, go ahead. What is it, about a minute and a half long, Wilma? A little longer?
The only reason we're wasting time with this is because the opposing counsel ordered the husband to leave the room.
Can you make it a little louder, please?
It's going to keep.
So, Fred, once again, and I say this with all due respect, you are one of the most ignorant people I've met in a long time. And your comments about this are ridiculous.
No, we're just going to stop.
Then leave.
Mrs. Lee is not, you're trying to take advantage of the fact that she's upset by continuing to argue.
No, Fred, what I'm trying to tell you is that you're being a jerk and that you're being an idiot and a jerk, and you've been this way the last 2 depositions. And I would really respectfully ask you to just sit there and be quiet and make appropriate objections, if you're going to make any at all, without making a speaking objection. Now, if you want to get on with this deposition, please do. But in the future, don't interrupt me with meritless comments.
I think you're the one that needs to get on deposition.
Sit down, Fred.
No.
Sit down or get out.
Why don't you get out?
You got it, Fred.
Want to go in the hallway?
And then do what? What are you going to do in the hallway with me, Fred? What adult, mature thing?
What are you going to do?
I'm going to walk out of here. What adult, mature thing are you going to do in the hallway, Fred? Huh?
What are you going to do?
I didn't ask you to go in the hallway.
No,
Why are you standing up? What are you doing, Fred?
what are you doing?
You're, again, seriously, your true stripes are coming out.
For the witness?
Sit down and shut up.
All right. I don't know how many of you in attendance have been in that kind of situation. My first take was, I want to know what happened. Did they ever go outside? And the other take I have is, who's the bigger jerk? I mean, the first lawyer started out by calling the guy an ignoramus, and the other fellow asked the other guy to step out in the hallway. Neither of them are very smart. I guess this is how bad it gets. Wilma, what's your take on that?
Well, I think that who was it? Fred, the attorney, was staying calm. Who was representing the witness was staying calm, and then he lost it. He lost control of the situation when he said, "No, you get out. You go down the hallway. What are you going to do?" And it's like, I know I am, but what are you?
He started out by calling the guy ignorant. You can't do that.
You can't. Yeah, they're both wrong. They're
That's
both
what I'm
wrong.
saying. Who's the bigger jerk? That's what I can't figure out.
Exactly. Yeah.
Chris?
I'm like you. I wish I was there to see who went on the hallway and who hit whom. Unfortunately, you do see this. And towards the end of my practice, before I retired from downtown, it was in some of the cases we had, it was a reoccurring theme where the attorneys just went at each other. A possible solution to this is if you reach an impasse like this, I would follow Wilma's suggestion about getting people in a room, trying to get it worked out as fast as you can, informally, coming back in and going on, continuing with the deposition. If you can't get that done, then make your record for a later motion in front of the judge, because you may want to go back and seek a protective order from the judge saying, if the deposition goes forward, I either want it conducted in front of a neutral at, in this case, Fred's expense, or I want it in front of a magistrate and let him ask his questions at that point. I don't necessarily want to have to come back and make another motion.
Yeah, I just think that you have to blow this up at this point and go see a judge.
Yeah, possibly.
Steve Austin in our county does, and I've just served as a discovery facilitator on a number of occasions. And what Steve does when there's a problem, Judge Austin does when there's a problem, he orders the parties into his chambers or into a jury room and makes them do the depo there. And if there's a problem, he basically sends them to the woodshed. And it's great. Like I said, I don't know whose fault this is. I don't know who's the bigger jerk. I don't know the history. I feel bad for that woman who's sitting there watching these guys be like teenagers on a schoolyard.
Yeah.
But that's no way to behave as a professional.
Good point, Andy. You can see the woman, the witness, is so uncomfortable, and I can't imagine putting my client through that.
No, it's bad. And I'm curious as to the group that's here today, if you've had anything like this. I really haven't, but I guess it does happen, and it's unfortunate. We can move on. What do you do if your client is uncivil to your opponent during a deposition? You take the client out of the room and explain to him that that's not helping his or her case. I mean, I have been involved in cases that are extraordinarily emotional. I don't do family law, and I would imagine that those are the most emotional. But a lot of my cases involves deaths of loved ones, and you have to explain to your client ahead of time that this is going to be tough. Litigation is difficult. I mean, it delays closure, not that you ever get it, but you delay starting getting it by going through litigation. And under 99% of the circumstances, there's no excuse for your client to be uncivil to your opponent. I mean, I guess there is an exception to that rule, but I wouldn't want to think of what it is. Chris?
Yeah, short of woodshedding, the client, I don't know that there's a real remedy for this. There are cases where there is extraordinary emotion on both sides. For a while, I did groundwater contamination cases, and you had people who would come in alleging a variety of maladies, and on occasion, the people that we might have a representative from the company there, and almost always they were convinced that their product had nothing to do with it, and occasionally said things in breaks and depositions and what have you that tended to stir up the other side, and you almost always had to take them outside and explain to them, you're really not adding anything to the equation. It's much better if you just simply sit there and take in the information. From a plaintiff's perspective, I would think this is an extraordinarily difficult thing to control, particularly under the situation where they have lost someone particularly close to them.
The only thing I would add, and I agree with your comments, both of you, that in another situation, I can imagine the client maybe has direct contact with opposing counsel, might be in a mediation. And there as well, it is not appropriate for the client to be uncivil to opposing counsel. And it goes to how you've prepared your client for the circumstances for what's going to happen at a mediation, and to make sure you avoid a situation where the client might burst out in a room where the opposing counsel is present.
One final point. As a lawyer, let your client vent to you. That's part of your job. I mean, you've got to listen. You've got to be a good listener. And these people often, and certainly in my situations, and I'm sure all of them, they're upset, they're angry, they're sad, let them vent to you. That'll help let off the steam, and it'll alleviate the need to be uncivil to the opponent, perhaps. But that's not a bad thought, I don't think. I'm glad we're at this slide. I see Judge Flyer is present. He just asked a question. And we'll get to that, Rick, in a second. Mediation is a great place for the client to get everything off of his or her chest, but not to opposing counsel, to the mediator. And the good mediators, most of them will allot a significant amount of time for that to happen, because so much of what's going on is pent-up anger, pent-up frustration. And so you could, when they're talking to the mediator by themselves, they could be as uncivil as they want. They could trash anybody who they want. When we first started doing mediations, and I'm curious as to what my fellow panelists think about this, they virtually all start with a joint session. And now we never have them. And the joint sessions were a disaster, because the mediator would look over to the plaintiff and say, is there anything you want to say? And then forget it. A half hour later, everybody was angry at everybody. But there's a time and a place at the mediation where your client can vent, and then you move on with the civility side of it. Wilma, you've done a lot of mediations. What's your take on all this?
I have, and during the COVID pandemic, I've done a lot of mediations by remote platform, often Zoom or some other similar platform, and those have been very successful. I agree that now we don't do so many, not very often do we do joint sessions, because there is the possibility of one client being offended by what me as defense counsel might say, or feel like they need to say something. My client might feel defensive, and it becomes more acrimonious than necessary. But mediations are remote mediations or in-person mediations are the opportunity for the parties, even though adversaries have to come to an agreement, or there is no deal, no settlement. One of the articles that is going to be part of the materials that is will be handed out to you is a Contra Costa lawyer, county lawyer magazine by Mark Lahaki from April of 2017, and he acts as a mediator, and he talks about civility and the mediation process. So I commend you to read that because it talks about mediation is a time for trying to work together towards a resolution of your case.
Yeah, I don't know if you all have access to the chats, but Judge Flyer, who's a mediator now, had a very important point that I want to call it to everybody's attention. He says that in mediation, I want clients to vent. That helps the work to be done. I totally agree. It also helps to allow opposing counsel to see human and express concern, to seem human and express concern. Both things are true. Mediation is a good time for all of this. And thank you, Rick, for adding that to this discussion. Okay, Wilma. Often on these panels, there's a judge, but we don't have one here today. So we get to discuss this. I tried a case in federal court in front of a judge who was sort of infamous for being uncivil. And he's a federal judge, and there's really, I don't know what the recourse is there. I'll defer this to other people. I mean, he was mean to me the whole time. And then after I won, he granted a new trial. No, judgment notwithstanding the verdict. So that wasn't uncivil. That was just awful. But, you know, I was on a panel, this panel, last year with the presiding judge of the San Francisco Superior Court, and I forget his name. And my comment to this question was, it comes with the job. You know, you have to deal with uncivil judges from time to time. And boy, did he take offense to that. And he just shot me down. And I don't think he was right, but I mean, so if there was a judge here, there was a judge would say, I would imagine that you don't have to put up with it, but I'm curious what my other panelists think.
We had a case in Los Angeles, large number of defendants, jury trial. And the judge was extraordinarily difficult, had a reputation for being that. But I suppose the silver lining was he was just awful with everybody.
Right.
And at some point, both sides got together and we tried to evaluate the effect that the judge's comments had on the jury, and could we describe it as a material effect on the jury. He would make comments during direct exam, comments during cross-exam, not necessarily belittling lawyers, but certainly kind of undercutting them or raising questions about how they were doing things. And it finally got so bad, we decided that it was materially affecting the case. And we elected a reluctant spokesperson, had a record cut for the previous 3 or 4 days where we had concrete examples. And then we asked the judge if he would come in early the next morning, which he did. And we basically presented our case and said, you know, this can't continue. Judge got really angry and we said, okay, that's it. We walked down the hall to the presiding judge's office, asked for a mistrial and a reassignment to a new department. And we got both.
Good. We just got a notice at the time. Wilma, how many more slides do we have?
3. So why don't we move on?
Yeah, let's do it.
Because this is an important one.
It is. Go ahead, Wilma. Why don't you take it?
So we've all been the recipients or perhaps the author of a nasty email, a letter, a voicemail to or from an opponent. We've, resorted to, if you resort to name calling somebody a nut job, incompetent, slimeball, crooked, crazy, psycho, pathetic. And you see that. And I call it kind of the poison pen letter or the poison pen email. And especially in this day of emails, remember, those documents can be printed, they can be exhibits, and the judge will be reading them as part of a motion. So my advice is when you receive an email and it makes you angry, the first thing you want to do is respond. Do not respond, not when you're angry. So what I do is stop, pause, reflect, write a response, print it out, leave it on my desk, come in the next morning, reread it, have my secretary or a partner read it, and then and only then, and tone it down to a professional response, or maybe no response. But that's how I would handle it.
Chris?
Yeah, I agree. Bill Smith and I used to preach the 24-hour rule. Look at the email, set it aside, let 24 hours go by, and come back in and make two decisions. Number one, is this really worth fighting over? If it is, then create your own response, preferably by letter, in a very straightforward, unemotional manner. Cite to what you consider to be the offensive material, attach the emails to your letter, and send it off to your opponent. And as Wilma pointed out, remember, sooner or later, this may wind up being an exhibit to a motion where you can acquaint the judge with the conduct of your opponent. But above all, wait the 24 hours before you respond.
Don't hit send. That's the motto. Thanks, Wilma. We can move along. Great. There's a new case, and this is important. There's a new case. It's from 2019, 42 Cal 4th, 504, Briganti versus Chow. I'll say it again, 42 Cal 4th, 504, out of LA. I couldn't believe this when I read it, but it talks about bias, and in this case, gender bias. It was a case involving slander and all that kind of stuff over Facebook, so you can imagine what it was really like. But at the end of the case, the judge wrote, having resolved the merits of this appeal, we would be remiss if we did not also comment on a highly inappropriate assessment of certain personal characteristics of the trial judge. And then they go on to say that one of the lawyers wrote in his appellate brief describing the trial judge as an attractive, hardworking, brilliant, young, politically well-connected judge on a fast track for the Supreme Court or federal bench, ruled for Chow. With due respect, every so often an attractive, hardworking, brilliant, young, politically well-connected judge can err. Let's review the errors. And the Court of Appeals went off on this lawyer and who claimed that he was trying to compliment the judge. And I'm curious what other people's takes is on this, because this isn't like direct incivility, it's inherent bias incivility towards a person's gender. And I'm sure there's examples for other inherent bias for other reasons, but it's important that we take stock of ourselves and think of before we speak or before we write. And the lawyer who wrote this, I mean, he or she must have rocks for brains, but I'm curious what other people think.
Well, objectifying or demeaning a member of the profession, male, female, and that, you know, gender, race, sexual preference, gender identity, any personal characteristics, any personal attack. I cannot imagine making a comment in a reply brief about a judge, but certainly you think about it when you're writing a letter, think about this when you are in a deposition. You've got perhaps a young female attorney on the other side. You don't want to be using cutie, sweetie. That's not appropriate.
Agreed.
I agree as well.
All right, thanks, Wilma.
All right, we're just about done, and maybe we want to turn to questions.
Yeah, why don't we do that? Are there any questions?
You guys have handled everything that's come in the chat, so there are no more questions. We can give everyone just a minute. If you have a question, put it in the chat box now.
While you're thinking about your questions, we quickly jumped over a slide about missing a deadline. and you
Sure.
should throw into that, we've got a couple more minutes here, granted extensions on deadlines. First of all, overlooks and missed the deadline. This is dicey. This is the one that causes me the most problems. Expert discovery, expert disclosure, someone's a little late. I mean, the judge is not going to let a couple of days stand in the way of an expert disclosure. You have to work that kind of stuff out. The one that I don't have the answer to is if the defense misses the deadline for the filing of the summary judgment. I think it's jurisdictional and you can't give them relief. But Wilma, you would know about that more than me. Not that you ever missed a deadline.
Not that I ever missed a deadline.
But it must have come up.
It has, and actually, truth be told, as a very new lawyer, I did miss a deadline by something like one day, and sought to work it out with opposing counsel. It was not worked out, but somehow we were able to eventually resolve the matter. So a lesson learned very early in my career. And so missing a deadline is not something that you should do, whether it's a discovery deadline, an expert witness disclosure deadline. These are obviously very important. But I think that you are well within your rights to call opposing counsel and see if you can work it out. But there's certainly no guarantee. And even during the COVID pandemic, the deadlines do exist. And we are all held to the same standard of Code of Civil Procedure, and we should all be abiding by those. So, you know, first line of approach is if you can work it out, do. Sometimes on a discovery deadline, you work out some sort of a compromise or a hybrid where you will respond and waive objections or certainly figure out some solution to the problem.
Right.
We did have one question come in, and it's about how to respond when opposing counsel accuses you of having ex parte conversations with the judge when you know the allegation is untrue.
Anyone who want to answer that? Howard has a question.
Well, I think if you have that kind of accusation, you're going to have to deal with it up front. And it's probably best done with a letter going back to your opposition saying, this never occurred. Please outline for me all of the evidence that you have that has convinced you that it has occurred. Depending on what they come back with, which is either a great deal of evidence or none, or if it's just speculation, the next step is, well, do I want to place this in front of the judge in question, if it's your trial judge or a discovery magistrate or whatever, and have this addressed full on by myself, the court, and essentially have my opponent lay out his evidence in front of the very judge that this is supposed to have taken place with. If it didn't occur, my guess is if you indicate we're going to place this in front of the judge and get it out in the open, that's the end of the matter.
Okay. All right. I think we're well over. Do either of you have anything more you want to add?
I would just like to say thank you to the litigation section and the estate planning section for co-sponsoring this event. And thank you to you, Andy, for moderating, and Chris Larange for participating on behalf of ABOTA in the San Francisco chapter.
Chris?
And thanks to all who participated as listeners to our lecture.
Yeah, and I really thank I just lost you for a second. I don't know if you lost me, but I want to thank everybody for attending, and Ann and the litigation section for putting this together. I've enjoyed it, and I hope it's been helpful.
It's definitely been helpful. There's a lot of great practice tidbits in there, and I hope everybody has, you know, found something in here to take away, something that can contribute to their practice. So on behalf of the litigation section, thank you very much, panelists, and everybody have a good day.
Thank you.